These days, businesses are built on the back of databases they've compiled, and fortunes are made and lost on making sure those databases are safe, secure, and proprietary. Obviously, the best way to keep a database secure is to never reveal the content to the public, because people can't copy what they can't see. But what happens if the content of your database must be public, or your revenue model relies on revealing or publicising your data? For example, publicly searchable indices or television programming schedules. If your content is out there in the wild, can you rely on copyright to step in and stop people from copying your content and profiting from your hard work? The short answer is probably not. The slightly longer answer is, well, it depends on what you're trying to protect. We know that anyone who claims copyright infringement must show firstly that copyright subsists in a work, and secondly that a substantial part of that work has been taken. Databases are the same. But in 2009, the High Court's judgment in ICE TV and Nine Networks Australia really impacted on the way that we think about copyright in databases. Prior to that case, the focus was really on whether a database could qualify for copyright protection at all. That is, the case is really focused on the first question. But since ICE TV, we think that question has become almost redundant. That is, even if copyright subsists in databases, the scope of protection offered by copyright for databases is so limited that few databases will actually be effectively protected. So what sort of databases will be protectable as copyright? The answer is best encapsulated in the oft-cited phrase, independent intellectual effort directed towards expression. Basically, this means that copyright law will protect a database if someone copies the presentation of the information, not if someone copies the content. Maybe the Hawthorn AFL selectors spent many agonising hours selecting the team that ultimately won them the 2015 premiership. But once they agreed, it was a very simple task to write the names down. The effort that went into essentially creating those facts is not protectable as copyright. This means that once they release the names, even in their nominated positions, anyone could copy them. That seems fair. But what if the database is far more detailed? The legal outcome would be the same. Unfortunately, this is largely bad news for database owners because it restricts the protection that copyright will offer. Basically, where the layout of a database is a key aspect of that database, copyright will probably be very helpful. The flip side is that where a database is valuable because of its content, it will receive much less protection under Australian copyright law. The EU is way ahead on this. In March of 1996, they adopted a directive which introduced a specific database right distinct from copyright protection. This protects owners against third parties extracting or using information in databases without permission. The point is to recognise the investment that goes into creating databases. Copyright still operates alongside this right and can still step in to protect against someone copying the layout of a database. In the wake of ICE TV, it might be time for Australia to follow suit and introduce measures which recognise the significant time and money which goes into creating and maintaining databases.